This very good legislation, introduced first in Queensland, makes substantial reform in that it substantially reduces the number of director liability provisions from approximately 3,800 offences to approximately 260 offences left in this state. Secondly, it changes the levels of liability to simply 2, and those apply to executive officers. The first is called Type 1 liability, where the prosecution has the onus of proving that the executive officer failed to take all reasonable steps to prevent the commission of the offence by the corporation. It will be retained in offences for areas of food safety, public safety, for example, public health, building safety, fire safety, water safety and reliability, and explosives. It will also apply to public and environmental safety in mining, gas, petroleum and nuclear activities, for child protection, for environmental and heritage protection, for animal welfare and revenue protection. The second type of liability is called deemed liability, and that will only apply to nominated offences, that is, not to all offences that might be imposed on corporations in legislation. And deemed liability will arise where the officer authorises or permits the corporation's conduct constituting the offence, or the person is directly or indirectly knowingly concerned in the offending conduct. The liability applies not just because of corporate offending, but because the executive officer's own actions in that offence occurring. And it applies to just over 100 offences in 30 acts. Not all offences in those acts, only those that are nominated. When the Attorney-General introduced the amending legislation into the House in October, he made it very clear that the Queensland Government's position in relation to director liability completely changed. Firstly, he said there will be no reverse onus of proof in legislation. Secondly, it will not be a matter of ordinary occurrence that this type of legislation will occur, that is, that there will be directors' liability. There will not be standard in legislation, and indeed it will be only included where it is appropriately justified. It removes nearly all the provisions in existing Queensland legislation which contain a reversed onus of proof, and that's a major and important issue for executive officers in this state. Some acts are outside the scope of the review simply because there will be other legislative reform which will deal with that legislation. An example of that is the Electrical Safety Act, where because of amendments that are imminent under the Workplace Health and Safety Act, the changes for personal liability of directors and officers will be dealt with in that legislation. That's an important question. The only people who will be the subject of liability after 1 November will be executive officers. An executive officer is a person who is concerned with or takes part in the corporation's management, whether that person is a director and whether or not the position is given the name of executive officer. So it's not a question of what a person is called, it's rather a question of what a person does, namely takes part in or is involved in or concerned in the management of the corporation. This should exclude non-executive directors who do not concern themselves with or take part in management. It does not diminish, importantly, the potential liability under the criminal code of executive officers who are parties to offences. So the parties to offences provisions under the criminal code remain. Directors not liable for acts of corporations who are not knowingly concerned in the conduct of the corporation's management that give rise to the commission of an offence will not be liable. It does not reverse the legal onus of proof for executive officers, and the prosecution must prove the elements of the conduct which constitute the commission of the offence against the relevant executive officer. Well, COAG sought that all participating states will drive these sort of amendments to legislation applicable to each state and territory of the Commonwealth. This legislation follows it directly. This legislation leads the nation in the way in which executive officers will be treated. The removal of the reverse onus of proof is a very significant reform for this state's laws, and the elimination of many of the offences from well over 3,000 down to little under 300 makes a significant difference to the business of Queensland being open for people to be able to have confidence to do business in this state, so that the economy of the state can be driven forward in a positive way. For anyone who has particular concerns about particular aspects of legislation that might affect them, they should ring us and speak to any of our team in relation to these issues.